welcome to Real Estate with Beth and Ben. I'm Beth Riebenstorff, founder of the Rebe HOMES team.
And I'm Benjamin Gottlieb, founder of the law firm McQueen & Gottlieb.
Okay, so Ben, another topic that's hot right now, tenants in common, so people coming together and buying jointly. I found that there are assumptions about what it means, and it's not accurate what they think it means and what it actually means, or what some of the risks might be. So in any of those cases, what do you recommend for people? What should they do to avoid that?
Well, it's hard to completely avoid any kind of argument by the other side that they have a property interest. After all, if you are conveying property, one thing you can do is have a written memorandum of understanding among the parties that documents the parties' rights and obligations associated with the property transfer and the property. That certainly helps. Another thing you can do is have a ledger of expenses and keep track of who's paying for what, who's paying the mortgage, and what the parties' expectations are with respect to that. By and far, the most important thing is for the grantor to know and understand that they are giving away a property interest at the time of executing that deed. And while I wouldn't go so far to say that necessarily is an irreversible act, it is a pretty strong act, and it might be difficult to unwind that property transfer. So just knowing that going in, so if it's a couple that's engaged, maybe you wait till you're married.
Right.
Not trying to sprinkle any kind of pessimism on the relationship, but that might be something that couple may want to consider.
Well, we see that after the fact, and at the time they're not thinking that way. But if there's been 5 years of appreciation and it was given away down here, then the benefit was significant versus if it were shared up here. There's a big difference there.
Another issue that pops up, Beth, in this context, especially with a rising real estate market, which we've seen over the past couple of years, is that one of the co-tenants may want to liquidate their interest. Let's say it's two business partners or friends that own the property jointly. The other co-tenant could be very happy retaining ownership of the home and doesn't want to sell. So that presents a conflict. Under the law, interestingly enough, there are what are called partition statutes, whereby the co-tenant who wants to sell the property most likely will be able to, even if the other person does not want to sell. So they actually have the veto power, even if it's two 50% co-owners. That's another key factor to consider. If you're a owner of property and you don't want to sell it for a very long time, and you add a co-tenant, you may be giving away your power to retain ownership of that property. Of course, you could buy out the co-tenant, but maybe the co-tenant is now demanding an unreasonable sum of money, or maybe there's other issues there that might prevent that outcome as well. So it's just very important to be aware of the risks before you put yourself in that situation.
So it's a good solution, but it needs to be thought out carefully.
Let's just put it this way: we get a lot of clients with these kind of joint ownership issues, and I'll leave it at that.
Thanks, Ben.
Absolutely.